Do you think the challenges we face today as practitioners or arbitrators or users are the same as they were?
No, they're much greater. They're much greater. I know that you criticise me for sometimes thinking of a golden age of arbitration when everything was simple and straightforward, and of course it never was. But it was a lot simpler than it is now. You get all kinds of interim measures going on during a process. I mean, you don't any longer start with a dispute, get to a hearing, and get an award. Along the way, you can have a long-running battle about disclosure of documents. You can have an application for security for costs or some other form of interim relief. So you get little mini battles going on within the general battle of the arbitration. And that makes it complicated, it makes it expensive, it makes it take a lot longer.
You've always got to remember that what we're writing about isn't substantive law. It's not what you learn at university or even at law schools. This is skills-based stuff. And if you reflect for a moment on what the things that Alan listed, interim measures and that kind of thing, and we can expand it to think of how to appoint arbitrators, jurisdiction issues, procedural issues of all kinds, then this book is not about, it's not like a book about the sale of goods.
They're saying this is the law.
This is the law.
And
this, yes.
No.
And that's one of the reasons it's descriptive rather than giving opinions.
Well, you refer to the golden age of the past, and another way of looking at the present is that we're now in the industrial revolution of international arbitration, the professionalization of the process, which means that practitioners and clients expect many more sources. They expect precedent, they expect predictability, and achieving that in a world that has become so much more diverse. You have a significant Brazilian arbitration community, a very live and active Indian arbitration community,
a Nigerian community,
a Nigerian arbitration community. Conveying the same procedural expectations across that world is a bigger challenge than it was before.
And that's, and it's a challenge for the arbitrator, as I said earlier, to make sure that people are in tune with you. They know what's happening, and they're content with the process because it's a consensual process. So it depends on the agreement of the parties, and so you want the parties to be satisfied that they are getting a fair deal, fair hearing. I think that's very important. And then you have management problems within an arbitration, but that's perhaps a different subject. How do arbitrators make a decision?
That's the multicultural point too, because you have an Indian arbitrator, a Brazilian arbitrator, and a chair, perhaps, or a third arbitrator. Any one of them might be the chair.
Working usually in English, predominantly in English. I'm, one of the vice presidents of the International Chamber of Commerce in Paris, their Court of Arbitration. Most of the awards that we see, and they come from all over the world, are written in English. And so you've got Brazilians, Nigerians, Venezuelans writing an award in English. They've argued it in English. And it's really quite impressive, actually.
This, of course, is because the contracts themselves are in English.
Yeah.
And you get people like Karl-Heinz Bergstiegel, for example, as a German, who regards German as a very difficult language in which to write a contract. He would rather write a contract in English than in German. And I think that is also true with Arabic, for example. As you know, I'm involved in Dubai, in the Gulf Arab world, and there, in the institution I'm involved in, we have about 20%, or we had about 20% of our cases in Arabic. But that's reducing.
Yeah.
But it's the rest are all in English.
And the law, of course, is not always English. I mean,
Law is hardly ever
the law could be anything. It's the language, which is English, it's the procedure, which is international, and it's the law, which is the law of any state that the parties happen to have chosen.